High Court appeal is directed against the judgment dated 23/12/2025, where Honorable Court, my lord, while adjudicating the case on merit, on ground of alternate remedy, available alternate remedy, my lord, has disposed of or dismissed my writ petition.
Yes.
After giving findings on merit, my lord, this matter relates to payment of gratuity, my lord. Gratuity of an employee, a regular employee of respondent number 3. Before the controlling authority.
Was the affidavits completed in the writ petition?
Yes, my lord. Pleadings were completed and writ was heard on merit, my
And
lord.
thereafter, the alternative remedy. Can you show me the operative portion there?
Sure, my lord. Sure. Annexure 1 from page.
Show me the portion.
Correct, my lord.
Four, if you can see.
My lord,
Page 6, para 4.
page
6, para 4. Yes, you have the questions. No, I have seen that. The first question. Then finding.
my lord, from page 28, running page 28 of my
Yes,
appeal.
Running page 19, I believe. Running page 38.
38, correct, my lord.
Yes.
38,
Yes,
my lord. Finally,
who is appearing for the other side?
Both respondent 2 and 3 are being represented by their respective lawyers, my lord.
Where?
My
Who are?
I am reading for respondent number 2 here, my lords.
My lord, I am repenting for respondent number 3. My lord.
Now tell me, sir, if the court entertains the writ petition, invited the parties to exchange the affidavit, is it permissible to relegate the parties to an alternative forum?
That's here the
At
court
the
did not relegate the matter. Here the court, Honorable Single Judge did not relegate the matter to the appellate forum. What the Honorable Single Judge has observed is that the matter is not maintainable. The petition is not entertainable since there exists an alternate remedy of appeal under the statute.
What is the difference? What is the difference that I could not make out a case if the court says it is not internable because of the alternative statutory remedy available? Then what does it mean? Not relegating a alternative forum?
Well, the Honorable Single Judge did not send it to the appellate forum to decide it. It only
Okay, they can. This observation, what is the law of the subject? It should be relegated at the very first day of admission,
yes,
or it can be relegated after the full-fledged hearing.
After hearing the parties and passing the judgment,
Show us. I am aware of a just reverse judgment. So
yes,
please
sir.
tell us, show us the judgment you have in your hand.
Once the party cannot be sent to the alternate
I understand it is
yes,
not an absolute bar that the writ is not obtainable because of the alternative remedy available. So the court must exercise the discretion at the very first day when the writ petition was made. But once the parties exchange their affidavits, everything has been done, then will it not be proper that the court should decide the matter on merit?
Well, it was decided on merits also. Two issues were framed by the Honorable Single Judge. One was whether the order passed by the controlling authority is sustainable in the eyes of law, and the second was with respect to the alternate remedy available with the matter. Now, from at paragraph number 16, at page number 35, the Honorable Single Judge has made some observation on merits, my lords. Para 16, page 35. The above exhibits and the bylaws of the OMFED are also going to show that the OMFED is the controlling authority of PUMUL, and OMFED is vested with all powers that is recommended, liquidations of any member union or primary cooperative societies, including PUMUL, have common service cadres for officers and staffs of the member unions. The selection of the petitioner was made by the apex organization of PUMUL, that is OMFED. and then his service was placed under the control of its subsidiary union, HON'BLE. Therefore, the fixation of joint liability for payment of gratuity dues to the applicant on the UMFED and HON'BLE, making them jointly and severally liable, cannot be held as erroneous, because the object of the Payment of Gratuity Act 1972 is to achieve social justice, and a liberal interpretation as well as wider meaning has to be given while interpreting the said act. That apart, for the interstate dispute between UMFED and the HON'BLE, the retired employee, that is Pramod Kumar Pani, should not be debarred from getting his legal gratuity dues. Well, this is the observation made by the Honorable Single Judge on merits. Here, my lords, the respondent number 2 had retired from his services.
No, I understand. This is
Yes, my lords.
in relation to a payment of gratuity.
Yes, my lords.
Yes, I understood. Yes, you were
Only
a point which appears to us at the very outset. Correct. But now the court has also gone into the merit.
correct, my lord. Now,
Yes.
after adjudicating the issue, my lord, which are crux of the issue, my lord, on merit, relegating me again to the alternate remedy, my lord, finding
modify the order. We can modify the order so far as the liability is concerned. It is a joint liability which has been held. So that is what is there, and there is no point of relegating him to
only
appeal.
crux is, my lord, holding me jointly and severally liable is not permissible because I am a independent entity.
Show us where is the bar? Where is the bar? Show us. Because he has relied upon the judgment of this court. He has relied upon the judgment of this court. Show us.
My lord, the response, it is there in the order itself, my lord, of the controlling authority, who took 12 months of apprenticeship period that the federation made the person concerned, my lord, trained, skilled, to make him eligible to seek proper employment. And he was regularly observed thereafter, my lord, from 17/3/1983 till the date of superannuation, 38 long years, he was regular employee of respondent number 3. He only got killed, my lord, under federation for 12 months. For that, holding me responsible, my lord, equally and jointly to discharge a liability of to the tune of 50,31,000 is not permissible, my lord. I am not the employer. Here, the employer is HON'BLE, District Milk Union, my lord. And it will set a very wrong precedence also for all employees of different milk unions of the state, my lord. There are 13 or 14 district milk unions all over the state. And my status as well as the different milk union status are separate autonomous independent bodies. They are cooperative bodies, my lord. Our relationship is just like a debtor and creditor, my lord. And we function in a 3-tier system, my lord. Federation being at the apex level, district milk unions are in the mid-tier, and the primary agricultural milk union society, my lord, which are primarily at the root level. And I can also, my lord, physically produce adjudication made by the same controlling authority in respect of other employee of the same HON'BLE and other district milk union where they have not, he has not casted the liability on federation.
Yes. Who is appearing for PUMUL?
My lord, I am appealing on HON'BLE. My lord, the UMFED is the HON'BLE is the affiliated society to the UMFED, my lord. UMFED is the apex organization. The maximum time the general manager posted by the UMFED, and UMFED takes milk without payment, without giving payment more than 2 crores. Pending against UMFED, my lord. HON'BLE is a small society, my lord. Most of the employees are controlled by the general manager. And general manager appoints HON'BLE. My lord, that point will be decided by the appellate authority, my lord. Appellate authority under section 7, subsection 7, my lord, of payment of the gratuity act. Instead of filing a PG appeal, the petition appellant has preferred a petition without petition.
Now, there is no question of any we wanted to hear out the appeal itself. The point is very simple, whether it is a joint
Very simple, my
liability or it is a sole liability of POMUL.
Correct.
So that is the only point which is available.
Only, sir.
Now, so far as the
And my
petition
humble
was
contention is,
filed,
my lord, sorry for interfering, sir.
but just wait, have a patience.
I'm
The
sorry,
writ petition
because
was filed by the appellant, which is dismissed. The writ petition was filed by the appellant, which is dismissed.
Yes, my lord.
correct.
Whether any interim order was continuing in the writ,
Continuing, my lord, till
what
the date
interim
it was
order was
finally adjudicated.
continuing, what
My lord, the respondent has retired in 2021. Till now, none of his gratuity dues have been paid to
Oh,
him.
I understand. This is a portion. Now the POMUL has not challenged this order.
No, he is there. They are conveniently
lord.
not challenging.
Now the controlling authority has said that both of you will share jointly equally.
Yes, my lord.
Equal liability.
Correct, my lord.
Yes, my lord.
Both of you.
Jointly, yes.
It was only a no coercive step should be taken against you, sir.
Sir, in my writ petition, sir,
In your writ petition, sir,
my
Mr.
lord.
Kanango, there
My
was
lord.
no stay of the operation of the order of the controlling authority. It was only a coercive action to be not to be taken. That means the order has its operation.
My lord, because of this, my lord, the order was not given effect to, and
I do not know. You say the stay, that is not correct because my brother has opened the writ file, has gone to the
which
order.
was passed, the order which was initially passed by Honorable Justice A.K. Mahapatra, my lord, single bench.
That is what, as an interim measure, it is directed that no coercive action shall be taken pursuant to the order under Annexure 1, that is the order dated 16/3/2023.
So,
Correct, ma'am.
so it is not a stay of the operation. Only thing is no coercive action.
No coercive action, ma'am.
So why you said the stay of the operation was granted?
My lord, that was wrong impression, my lord. I am carrying the other appellate file, my lord, appeal file, my writ file. And one more prayer, my lord. Before the controlling authority, it was nobody's case that the respondent number 2 is not entitled to gratuity. Rather, it was admitted fact and admitted case of all
I
parties.
understand, sir. You need not have to. Yes.
My lord. Sorry, my lord.
D'accord. The writ petition filed by the appellant was dismissed after deciding 2 points, namely whether the Yes.
Item number 2.
May I
please, my lord.
That I have already said. Yes, who is appearing for the appellant?
My lord, I am appearing, my lord.
Yes, what is the matter?
My lord, yesterday this writ appeal arises from a writ petition wherein transfer order has been was in challenge. Yesterday I had supplied a document before your lordships and no one was appearing for DSGI. That's why, as per your lordships direction, I have communicated them through email to appear today.
Yes.
My lord, I want to
I didn't
place that.
understand. Nobody is appearing means I don't understand. Follow. Last occasion there is a direction for.
Yesterday it was there, but since last hour we could not
Oh,
appear.
acha. Last.
Oh. Yes, now you are appearing.
Yes, yes, you are appearing.
Okay.
My lord, I want to place the letter dated 15/5/2006, which I had supplied yesterday, my lord.
Yes.
My lord, I want to place that, my lord. Last paragraph I have placed yesterday. Today also I am placing, my lord.
Oh, yes.
Yes, my
Mr.
lord.
DSC,
Yes, ma'am.
I think on the last occasion you communicated to us that so far as the entire facilities or amenities which are required to be extended to the writ petitioner is available at the transferred post.
Yes.
There is no difficulty. But now the letter is issued by a commandant of a 175 battalion, where he has said that it is also informed that there is no government accommodation available in this unit in which above psychiatric patient with his family can be accommodated. Keeping in view of the above, it is requested that the above individual may be transferred to any static office by cancelling his transfer from Odisha sector headquarter to some 175th battalion for his better treatment, please.
Then let's
With
see,
the-
ma'am.
with the
That instruction I didn't have. If they
With the
got it,
7
then
exclamation.
yes, yes. If
After
this is an instruction from a commandant, because it's not a level of command to decide. I'll say headquarter and they will do the needful. Just give me, let's me urgent the matter and give some
Only
time.
thing is that the doctor has said that since he has some psychological or psychiatric problem, the presence of the members all along with him is also very much necessary.
That's
And
true.
you said
That's
that
true.
the family can live there. There is no difficulty. The family can give us support. So we were of the view there is no difficulty in this regard. But now this commandant has said no, 175th battalion does not have.
So I'll take the instruction. Let's make it some time after vacation. Let's make keep it.
My lord, one humble submission, my lord.
He must not be getting a salary or what.
My lord, this is a reply to the letter of the DIG law, my lord, New Delhi. If, my lord, I want to take your lordship to the first page. This is a reply of the DIG law DT. Kindly refer to your office signal number J241/2026 DA9 dated 14/5/2026, my lord. It's a reply which has been made by the DIG law DT, the first line of that letter, my lord.
Yes, I have seen.
Internal communication.
Whatever is otherwise, London DSG was saying that they have all infrastructure, they have all facilities.
I have that instruction. That's why I'm submitting. I have not that.
Commandant says
But
no,
how
we have no
the commandant
facilities.
saying so? Matlab again I have to verify all this.
Now the position is he is where he is now.
At Bhubaneswar, my lord, that is also observed
He
here.
has
my
already
lord.
been relieved from Bhubaneswar on 8 April.
Yes.
He has already been relieved from Bhubaneswar on 8 April. But he has
So
not
what
joined
to
at
do?
175 battalion.
Now what to do, sir?
Let's see, keep it to day after tomorrow. Let's see, keep it day after tomorrow.
That's a very easy way. But what would happen to
No,
his salary? now Mr. DSG, both of you, what would happen to his salary? He has been discharged from the headquarters. He's not able to join the 175th Battalion. Now where he will
there
be?
is no difficulty to join and there is no difficulty to get another order.
Sir,
He,
he's
what
a
is it a
psychiatrist.
transfer case? He has
He's
to
a
join any
psychiatrist
particular place.
patient.
Yes.
Mr. DSG, had it been a normal case, no problem. He is a psychiatrist
We are
patient.
accommodating since long. It is not that today it is suffering and we are not giving importance. He is suffering since long. We are also giving all support to them also.
I understand, but in 175 battalion, you have no infrastructure, no facilities.
My lord,
What you will provide?
are you
ready to-
there is
are you
other
ready to
battalion, other
burden-
force are there.
Mr.
Yes.
DSG, are you ready to burden if anything happens to him? Will you burden the responsibility?
Man, we definitely will take responsibility
We will
of
direct him
our
to go.
guy.
But
So
but
what
will
I am praying,
you
my
take
lord,
us-
what
take a
reference he is communicating.
responsibility?
My lord, what I am praying, my lord, my limited prayer will be, what instruction they are doing, it is coming to him, but not to us. So it is also strange.
No, it is
I will
not to
take
you.
instruction from the officials. Definitely, if this is a problem, then I either he have to return this donation or he has to give another place. There is no alternative.
Mr. Pari, kindly appreciate how will he be in a position to get himself treated anywhere because he is already relieved. He is not, perhaps he is not getting any salary also.
It is a matter of 2 days, man. I am praying, my lord, for tomorrow, day after tomorrow. I'm
Last
taking authorized.
occasion,
I'll ask the IG to give some all benefit, all sort of facilities
in
to
the
him
month of May.
here itself. Yes.
Sir, on 4th May, the same thing. We passed a very elaborate order.
But because he's not joined in that place, we are also not able to give any sort of benefit to him. So what I'm praying, my lord, either
Mr. DSG, at
My lord,
least we are conscious that there is a very limited scope under the judicial review against an order of transfer. We are conscious, but equally we are also conscious that if a person who has a who is passing through a difficult time is a psychiatrist patient. The doctor has said that yes, he needs a constant the support
yes.
from the family. He is under medication. Give him some static duties. He is otherwise ready to do it. Is capable of doing it, but not a very rigorous duty. So the human approach is human touch is also involved in that. So what is
Definitely, my lord. I am completely agree with my lord. I am not different. So what I am praying, my lord, because then my lord, because they are giving instruction about, they are giving facility, all facilities.
Have you
Now they are giving
Mr.
another
Mohanty,
letter.
have you given that letter to Mr. DSG?
Yes.
Yes, my lord. Yesterday I have supplied through email, my lord.
So
I am not gone through it because I am not checked it up email also. It's not
check your email.
possible to verify everything email.
Mr. Dipti,
My lord.
have you received this instruction which has been given by Mr.
No,
Mohanty?
no. He has not solved a copy to me.
He has not, sir.
No.
So today, let him give a copy to us today. By tomorrow, I'll get the instruction. Day after tomorrow, I'll appraise the court everything. Your team may pass necessary order.
I have already supplied through learned DSGA email, my lord.
No, anyhow, I understand.
It is not possible to
yes,
verify everything on email.
Yes.
Not possible.
Mr. Dipti Ranjan Gupta.
Respondent number? Representing home.
He is along with Mr. Pari.
Along with DSG.
He is by CGC, my lord, Central Government Council.
Okay.
On a DSG.
Yes. The
3.
Item number 3, I am there, my lord. My lord, yesterday your lordship condoned the delay, but I think the same noting has come today. I don't know. Your lord,
What?
towards the end
Oh,
of
that.
yes, my lord, review, there was a 1-day delay.
So yes, there is no difficulty. Why you go by a technicalities?
No,
Come.
it has been listed for that actually. That's the reason why I indicated.
Are you ready to argue review?
So what I beg to submit that I am ready to argue, but physically it would be better to communicate. So if your lordship fix it to after holidays.
Yes, after holidays.
Great, my lord.
Thank you.
Because online actually little bit difficulties is there.
No, sir. Nowadays there is no problem.
But your lordship has a lot of facilities there. Actually, we have got limited facilities here.
No.
Grateful, my lord.
Item number 4.
Yes. Who is appearing in 4?
Upper respondent, my lord.
Who is for the appellant?
I am appearing for the appellant, my lord. There is a delay of 157 days. I have already served copy on Mr. Khuddia.
And I have also
Yes,
filed
Mr. Kuntia.
yes, my lord. I have filed an objection to that delay condemnation petition, my lord.
You have filed?
Yes, my lord. I have filed in the registry today and also served a copy to my lord senior.
Okay.
My lord,
Have you got it, Mr. Government Advocate?
Yes, my lord.
Mr.
I have
Government
not-
Advocate, have you received the copy of the objection?
copy has not served on me, my lord.
In the office, my lord. In the office, I have served
We
10:30.
have to serve the copy today.
I have
I have not
already served.
received so far.
Already served.
Mr. Kuntia, you give him a physical copy when the learned government advocate is appearing. So
Yes,
please give him a copy.
Well, I will give in course of the day.
Submitted by Mr. Kuntia that he has filed an objection to an application. Some promptitude into it.
My lord.
No. Yes.
Test admission item number 1, WPC 5686 of 2020.
Who is appearing in item number 1?
Your Lordship, I am for the opposite party.
Devo Prasad Misro.
I am for the opposite party.
Where is Mr. Devo Prasad Misro? What is this?
RC cancellation.
Registration cancellation.
This is a matter of registration cancellation.
Upasana Bado.
Acha. Upashna Bado.
I'm appearing physically, Your Lordship.
Where?
I'm in the
Oh, is it? Oh, why you are appearing physically when today is a virtual day?
Pardon me.
Yes, RC cancellation?
Your
Yes,
Lordship.
Your Lordship. Yes, Your Lordship.
Yes.
Item number 2.
Kajol.
Kajol Sahu, where is she?
May I please, Your Lordship? My Lordship, I am appearing on behalf of the petitioner in this matter. Lord, this matter pertains to 734B.
Yes, my lord, I am appearing for the opposite party
When
department, my
the
lord. It
matter is
is
fixed in the Supreme Court,
My Lord,
My
it's
lord.
still pending.
still
still
pending, my lord.
pending. Okay. Yes, 73-4B.
Item number 3.
3, Archana Behra. You are?
Yes. Archana Behra.
Yes, my lord.
Yes. What is this?
I am court, my lord.
Yes, what is this matter?
RC cancellation matter, my lord. I will
Your
file
Lordship, no, your Lordship, I have objection here. Here, this is the cancellation of RC due to non-conducting the business in the place of business, Your Lordship. So place of business is the dispute, and he has not enclosed a single document to prove that he is continuing the business. So let him file one additional affidavit, and I may be permitted to do an inquiry.
It is submitted by the counsel for the petitioner that the challenge in the instant writ petition
Item 4, Your Lordship, RC cancellation matter.
Your Lordship, RC cancellation.
Yes.
Item 5.
Asit Das. Yes.
Ashit
Mr. Rai.
Kumar Das.
Mr. Rai. Mr. Aditya Rai. Unmute yourself. Unmute yourself.
It's a 73-4B matter.
73-4B matter.
Yeah, I'm appearing for the opposite party, Your Lordship.
Item number 6.
AN Rai लिखिए. Purvokist AN Rai.
Who is Sheikh Imtiazuddin, SS Ali and SS Swain? Item number 6. Who is
Your
appearing
Lordships.
for yes.
Yes, sir. I'm appearing on behalf of the petitioner, Your Lordships.
Yes.
It's a RC cancellation matter, Your Lordships.
Your Lordship,
Yes.
Your
Who
Lordship,
is for the other side?
Your Lordship, I am for the
Yes.
RC
Next.
Item number 7.
Item number 7 is also RC cancellation, Your Lordship.
RC cancellation, Your Lordship.
Yes.
Item
Yes.
number 8.
ZM वाले से
Item 8.
8 RC cancellation. Her case may be allowed.
Yes.
Item number 9.
My lord, item number 9 relates to multiple assessment here. But here, my lord, I have an objection, my lord. Here, my lord, there is a misrepresentation of fact. If your lordship will see page 13 of his writ application, he has stated that he has raised a point before. This is the order in adjudication is under challenge, and he has raised a point that single show cause notice for multiple financial year is bad. But in the reply which he has annexed, there is not a single line I have found regarding this, my lord.
But the fact remains it's a
File counter.
Yes, my lord. I will file that.
Mr. Bismay, file count.
File
My
counter.
lord. My lord.
By 1 week after
Vacation,
reopening,
similar orders may
rejoinder if any within 1 week thereafter,
My lord.
2
Usual
weeks after the reopening. Give a date.
9 July.
9 July.
similar order.
Similar order kindly be passed, my lord.
What?
Action. Regarding multiple years.
Regarding multiple assessment here, no coercive action.
Mr. Jivan,
My
have you
lord.
not heard the objection raised by Mr. Prusti?
Yes, my lord, I have heard that.
He is raising the objection that you have not taken a single stand before the authority concerned, that it is involving multiple periods.
But that's
So he is raising objection. He will file reply.
Oh, okay.
My lord,
Please allow him.
my
Please
lord,
allow him to
my
file.
lord, my lord.
Yes.
Item number 10.
Obliged, my lord.
My lord, so item number 10 is the RC cancellation matter.
Yes. Who is for the other side?
Your lordship, I am appearing. Deva Prasad, Mr.
Yes.
Item number 11.
Obligation.
Item number 11 pertains to cancellation of GST registration.
Your lordship, I am appearing. RC cancellation.
Yes.
Item 12.
That's why I am appearing.
4B.
That's why I am appearing for the revenue. Lordship.
73 4B.
Yes, Lordship.
My lord, 73 4B.
Yes. Next.
Item 13.
73 4B, my lord.
My lord,
Yes.
I am appearing.
Yes.
MK Mahanti.
Yes.
Item number 14.
73 4B, my lord.
I am
Yes.
appearing, my lords.
Yes.
Yes.
Item 15.
I beg your pardon, I am appearing in this case RC cancellation lordship. Item
Yes.
15.
15. Who is for the other side?
I am appearing, your lordship.
Yes. Yes.
Grateful.
Oblige you, lords.
Weekly daily list. Trace submission item number 1. WPCL 26 of 2026.
This is the National Security Act matter, my lord. My retention, the returning authority was not considered till then by the returning authority.
So this is the
Last occasion, lordship pointed out a judgment of Supreme Court in case of Pramod Singla versus Pramod Singla versus Union of India, my lord. That has gone to the judgment, my lord. That's, and see the para 35 of the judgment, my lord.
Where is the judgment, sir?
Lordship pointed out the judgment on that last occasion.
Yes.
Lordship pointed out that judgment, my lord, last occasion. Pramod Singla versus Union of India.
Oh, you come tomorrow?
No, they can address.
No. Live streaming is off. Oh, I read it. It is. Who is appearing for the prisoner?
Please, your lordship. I'm for the item number 2, your lordship. I'm appearing through BC, your lordship.
Yes, everybody. I am also appearing through VC.
Lordship.
Yeah.
Lordship, here is the matter is the petitioners belongs to Narayanpur block, your lordship. They
Now you have made a representation flagging an issue of illegal mining. No steps have been taken. Yes.
Lordship.
Why you are not taking steps?
With regard to that, I have to obtain instruction.
The proper instruction not required. Last day representation.
Long back in 6/11/2024.
Yes, as representation has been done. You go and decide the representation. Take a decision.
My lords.
Representation.
Disposal of representation within 3 weeks from the date of the communication of the order.
Item number 3.
Yes.
Without expressing.
Yes, who is appearing in 3? Alok Kumar Mahapatro, B. Panda. Nobody is appearing. Nobody. None appears in support of the petition. This is the matter after.
I submit my lord. The petition is a lessee of Blackstone Quarry, my lord. And at the time of handing over of the lease the quarry to the petitioner, my lord, there was no measurement and there was no drone survey conducted by the Tahsildar Dharmasala. And all on a sudden, my lord, on 15th of 2023, and so cause notice was issued to the petitioner by the Tahsildar under Annex 8, my lord, alleging the over extraction, my lord. And subsequently, the petitioner has submitted his preliminary inquiry report with a request to submit the details of the survey of the conducted by the Tahsildar. As the Tahsildar did not furnish any document, my lord, thereafter there is a demand of the Tahsildar by the Annex 11, and petitioner filed writ applications in this honorable court. Your lordship may kindly see the order, page 115, my lord, Annex 12, my lord.
So let them file a counter. You have already deposited the entire money. File a counter. Because on your representation, they have revised the demand and reduced it to practically half. Let them file.
And in the manner certificate case has been instituted, and the certificate
He has already deposited the entire amount. There is no question of it. Yes. Rejoinder 1 week after.
My lord, item number 5 on behalf of Mr. Sisir Rautra may be prayed for after vacation, my lord.
After vacation.
Okay.
Item number 6.
Item number 6, my lords, I am appearing through. My lords, item number 6, it is similar to WPC number 21664 of 25, my lords, and your lordships have issued notice in that, my lords. It may be tagged along with that, my lords.
What is the matter?
My lord, this is a matter concerning, my lords, the petitioner was not able to do the querying activities because the query was filled with water. Now they have raised the demand that even though I have not done the querying activities, they have raised the demand for deposit of the royalty and other charges, my lords.
Yes, let it be tagged. Give that number. What is the number?
WPC number 21664 of 25, my lords.
21664,
my lords.
It is posted to?
It was posted, my lords. It was this week, but after notice matter, it has not come, my lords. It will come after vacation.
Mr. Somya, what is the year? 2020?
25, my lords.
25.
Item number 7.
May I plead, your lordship? In this case, your lordship kindly see impugn order at Annexure 2, page 12, my lord. Without giving any notice and without giving any opportunity, penalty has been imposed, my lord. And Lordship, in a similar matter in WPC number 35381 of 2025, decided that issue, my lord.
Yes.
Yes.
Penalty 51, if I remember.
My lord.
3-5.
Yes.
35381 of 2025.
Yes. Let it come along with that.
No, we have already decided or not decided.
Ms. Patnaik, that case was disposed of?
Disposed of on 24/3/2026, my lord.
Yes, the same judgment will apply here.
If the order is that for giving hearing of the parties, following natural justice.
Sir, I think the point involved herein, whether the authority has any power to impose a penalty under Rule 51
No, illegal stacking of
OMMC rules. It is only on the court.
holders. Illegal stacking of holders. Therefore, the imposition has been made. This allegation
Have
is
you read the judgment?
Mr. Swine, Mr. Swine, have you taken note of that judgment which Ms. Patnaik is citing? That is delivered by us, interpreting Rule 51 of the OMMC rules, saying that the Tahsildar or mining officer has no jurisdiction. You take note of that order. The mining officer has no jurisdiction to impose penalty invoking Rule 51 of the OMMC rules.
I'll check up that judgment, but I have not seen that.
Mr. Swine, I think up to number of judgments or the orders have been passed based upon that judgment. I remember in 2 of it, you appeared.
I myself?
Yes. We simply say that so far as the penalty component is concerned, it is not within the powers of the mining officer under Rule 51. It is the jurisdictional cognizance taking court who can impose penalty.
No, Lordship, pass that order. No, sir. No objection. Lordship, pass that order.
Only the penalty component. Other component we have not touched. Miss
Patnaik.
Other component we have not touched.
Only penalty, my lord.
Yes. You'll have to deposit the other component that you cannot shy away.
My lord.
That is what? Pranat, something. There are 2 judgments.
Singh versus State of Odisha.
Yes.
Item 8.
May I please?
Yes.
May I please, your lordship? May I please, your lordship?
Yes, you are already pleasing us. No problem.
Hello.
Mr. Mahanti.
May I please, your lordship?
Mr. Malay Mahanti, please.
May I please, your
argue.
lordship?
Please argue.
My lord. My lord, this is my limited prayer. The proceeding was hearing on 22/11/2002 under Annexure 1. Till it was not published. Lordship, kindly may direct the opposite part number 3 to publish that proceeding results. Only limited prayer.
Lordship, Millard, I have passed on an instruction in this matter on WhatsApp to Mr. Loknath Millard. Lordship may see pay, if that is there, Millard. Lordship may see para page 4 and page 5, Millard. my lord, some facts are not stated in the writ petition. My lord, first of all, that order was passed. They have challenged that order in appeal. That is not stated in the writ petition. And
No, I am not in appeal. Thereafter that is
and thereafter, my lord, they have
appeal
filed a
pending.
civil suit, my lord.
That proceeding, that hearing was complete on 22/11/2020. It was not published, but thereafter, the opposite party number 3 under annexure 2 demanding to the petitioner under 21(1) without dispose of this proceeding 22. That is only
Sir,
my
what the additional government advocate is submitting before us, that this, on the basis of this personal hearing on 22/11/2022, the order is passed and published by the authority. You are aware of that order. You have challenged that order before the appropriate forum. You have suppressed all those facts in the writ petition. This is what his contention is. Your contention is that you do not know any decision has been taken on the basis of that personal hearing held on 22/11/2022. And therefore, they cannot raise a demand unless they take a decision. But the decision has already been taken. You are suppressed. Let them file a counter affidavit, disclose all those facts, annex the relevant documents. We will see to it. No problem. Counter 1 week after, rejoinder 1 week thereafter. Keep it in the 3rd week of July.
Public.
Item number 9.
obliged.
May I please your lordship, my lords?
Yes.
My lords, I pray for the matter to be listed after vacation, my lords.
Next.
Item number 10.
Item number 10, may it please your lordship. My lord, this is a similar matter your lordships have already dealt with. I was running a lease. I'm a lessee, my lords. And because of the construction of a petroleum reservoir at that area, I have already, my lords, for 2 years I have operated the lease. The rest 3 years the government may take.
Rule 64 to be invoked.
Yes, my lords, exactly, my lords. Your lordships have also passed another.
Yes, we have.
Yes, my lords.
Let the government take a decision.
Deeply obliged, my lords, deeply obliged.
NGT.
Yes. Next.
Item 11.
My lords, this is not NGT, my lords.
No, I understand. This is not a case of a NGT. We were just reminding them.
Yeah,
We have passed a subsequent order, Sukanto or something. We have passed
in Prashant Kumar Jaina, WPC number
Yes.
4615 of 2026. I'm giving a copy of that order for your lordship.
Yes.
Item 11, my lord, prefer after vacation, your lordship.
Yes. It is there on my desk, right hand side.
Copy the matter.
You have kept that. Yes. 12 already adjourned. Yes.
Item
30.
13.
Item 13, may please, my lords. And
Yes.
after vacations, my lords.
After vacation.
Yes, my lords.
Yes.
Item 14.
14, who is appearing?
So Bhagyaswari, on behalf of I am appearing.
Yes, what do you want, madam?
I want adjournment. Can it be listed after vacation?
Yes.
Thank you. Obliged.
Anup Kumar Patnaik. After vacation.
Item 15.
My lords.
15.
Yes.
Lords.
15. Submit.
I give Advocate Kiran Kirtirath appearing on behalf of Anup Kumar Patnaik.
What
My
do-
lords, after vacation, if my seniors.
Yes, after vacation. Next.
Item number 16.
Item 16, may I please your lordship?
Prakash Dhar.
Yes. May I please your lordship?
You are not visible, sir. Yes.
May I please? Sir.
Yes, sir.
The order impugned is under Annexure 1 series. That is a transportation of earth in a tractor that was seized by the Tahsildar and pass a order imposing a penalty of 5 lakh rupees. But that was passed in the year 2018. If your lordship kindly have a glance to the page 14, that order was annexed along with the notice which was given to me.
In 2025, they have reminded them that you have to see.
But prior to page 14, if your lordship kindly have a glance to the page 15. Page 15 may place that paragraph.
Rule 51 OMMC clearly states that whether any person is found extracting,
that is
transporting,
this he's saying that
No. If your lordship kindly have a glance, page 15.
in this matter, Kauzik.
Yes.
He was agreed to release the vehicle by paying.
Your lordship kindly. Yes, your lordship kindly have a glance to the page 15. Page 15 of the brief, my lord.
Yes. Yes.
May I place that paragraph?
You agreed to pay royalty and penalty so that your vehicle will be released.
Yes, my lord. If so, then what prompt the authority to issue notice? Then your lordship come to page 14.
Have you deposited that amount?
No, my lord. Because once they have stated that I have agreed to pay, now here in the page 14, they are saying that they have issued a notice, I have filed a show cause and taken some plea that was turned down. My lord, both the plea in the said impugned order is, my lord, mutual destructive. Apart from that, my lord, if your lordship, section 3 of the Odisha minor mineral concession rule.
Sir,
that is
you
clearly
are
in the
challenging,
procedure of the.
sir, you are challenging an order passed way back in the year 2018. This
But I
order
was not
remained
aware,
binding on you. You were aware. You agreed everything to pay. Now, after such a long time, they just raise a demand that this is pending. You have not paid it. They have issued a notice to you.
No, my respectful submission, my lord, that was I was not aware. Because
What
I
are
was
you talking?
not
Where you have stated that you were not aware of this particular order?
My lord.
Of 27/7/2018. Show us that you were not aware of 27 order.
Your Lordship, may kindly have a glance to first paragraph of the order itself at page 14.
Yes.
A so cause notice was issued to him. He replied to the so cause notice.
He appeared.
Yes, he appeared. And he
Yes, sir. You, Mr. Das.
Yes,
You tell me whether this order of 2018 was duly communicated to him.
Yes, my lord.
No, but it is very much aware from the order.
No.
That is why I am submitting.
Yes, Mr. Dada, please. I am asking a question to Mr. Das.
Your lord, the answer, my lord, my answer is at page 15. Page 15, your lordship may kindly see the memo at the bottom. Memo number 2442 dated 27/7/2018, copy to Sri, the petitioner's name, that is.
Was it sent? You just
Yes.
so that you may have, but have you actually sent or dispatched?
Yes, my lord. That I'll produce that.
Please, because he has taken a specific plea in paragraph 4.
I'll produce that.
Produce.
Yes, my lord.
Therefore, the order passed by the competent authority
to this.
Similar.
It's same.
Same.
Yes.
Similar.
Yes. Give 90.
Item 18.
May it please your lordships. Well, this is a writ petition for extension of the mining lease. Your lordships have passed similar orders.
64.
Yes, my
Rule
lords.
64.
Yes, my lords. May I share the order on the screen, my lords?
Yes. Yes. Yes.
The screen sharing. Give the screen sharing.
Is the leaseholder of Devfolks and Query, my lord.
NGT.
No, my lords, this is regarding the penalty, my lords.
Yes,
My
my
lords,
lord.
this is regarding the penalty, my lords. I'm
Yes.
challenging Annexure 4, my lords. The penalty imposed by the petitioner by the mining officer, my lords, under section 51, my lords. This honorable court has passed the order in Shashank Yadav versus State of Odisha, my lords. My lords, and the second ground is that I have not been provided with the drone survey report, my lords.
What?
No opportunity of hearing was being provided to me, my lords. Kindly have a glance over page 50, my lords.
No, sir. We can only interfere with the penalty.
Yes. My lords, no SOCO's notice was being issued to me, my lords.
No.
No.
For a moment, my lords, kindly have a glance over page 50, my lords.
Page?
Page 50, my lords.
Yes.
50. An amount of 2065, fourth line, my lords. An amount of 2065.2 cubic meter of excavated within the lease area and 5695.85 cubic meter illegally extracted from the outside of the lease area, my lords. Kindly have a glance over page 40, my lords. I have been allowed, my lords, page 40, my lords, 40,000 cubic meter of sand, my lords. I haven't extracted 1/10 of that area, my lords. 1/10 of the quantity that has been assigned to me, my lords. I've only extracted 2,000.
Difficulty, with all the humility which I say, the difficulty here is
yes,
that your pleading is something else, your prayer is something else, argument is absolutely different. Anyhow, penalty we can interfere.
I humbly pray that the matter be demanded back to the money. I would. Lord.
51. This ground number F at page 10.
Yes.
I humbly pray that the matter be remanded back. And opportunity of hearing may be granted to me.
Where is the provision?
Only
E will suffice. Only penalty.
That is what I'm saying.
Yes.
Now he is expanding it.
My lords, no drone survey report has been provided to me before imposing penalty on the petitioner, my lords. Nothing has been supplied, my lord. No materials has been supplied to me.
Main focus is
Under Annexure 3, they issued a letter that the drone survey would be conducted on 3/1/2026, my lords. Then on 12/1/2026, they supplied me a demand notice, my lords, without giving me opportunity of hearing. I've never placed my.
Where is the ground that you have not been provided with? You are focused only on 51.
51.
You are focused only on 51, Rule 51.
Yes, my lords.
So that's why I say
page 11, H, my lords.
Yes.
For that, the drone, UAV, DGPS and image data processing techniques were never provided to the petitioner, my lords. Ground number H, my lords.
Was it the notice
Yes, my lords.
that they have ascertained from that drone survey?
My lords, actually, no drone survey report was being supplied to me.
Where is your notice?
Notice is at page 49, my lords.
Then how could you make this allegation that drone reports were not given?
Page 49, my lords, last line, my lords, page 49. He is requested copy forwarded to Pankaj Kumar Jena, Niranjan Pradhan, the petitioner, my lords, Bhavesh Kumar Bose and Swamdeep Chakrabarti in respect of Ambaguruchi, Devog, Kadian and Dhipura Sand Query for information necessary action is requested to remain present during the drone survey work and deploy the representative for the aforesaid work on 3/1/2026, my lords. I was present, my lords, but no drone survey. After that, they have issued the demand notice under Annex of 4, my lords, 12/1/2026.
But the drone survey was conducted in his presence only.
They have never supplied me any documents. Nothing has been provided to me. That is my government. No report, nothing, no so cause notice. Why I shall be penalized or not? I was provided with 40,000 cubic meter of sand, my lords. I have only extracted 2,000 cubic meter of sand. 2,000 some.
Mr. Counsel, when you received this Annexer 4,
Yes, my lords.
have you
I made a representation, my lords, under Annex of 5, my lords.
for supply of that? Have you ever demanded from the authority concerned for supply of those documents?
No, my lords.
Then, if you don't demand, where is the question of consideration?
Sir, his case is that somebody who is stealing therefrom, he is not stealing. That's his case. It is not a case that it has not been extracted. It simply says that somebody else is stealing it. That is our Annexure 5.
Yes, my lords. So humbly pray that let the matter be remanded.
You have asked for an extension. The extension was pending, and this is a case after the expiration of the period of the lease. So we will not. The thing is a penalty, nothing more than that.
Humbly pray, my lords, let that.
It's all brain child. Only penalty, nothing more than that. Yes.
I humbly pray, my lords, let the matter then be listed after vacations, my lords. I will satisfy your lordship. I will take instruction whether he has made any request for
No
that.
demand was made to supply.
Sir, you are taking a stand which is an unbelievable stand.
As reflected.
Somebody will steal. You are still seeking for an extension. That means you are still retaining the control.
No, my lords, I am not.
No, sir. Then you do it. File the counter affidavit. You disclose everything, Mr. Das.
Yes,
Disclose it. 1 week, 2 weeks, after 3 weeks. Nothing.
Counter.
Item 20.
Yes.
Item 20, may I please, Your Lordship? Your Lordship, I am praying for extension of lease period for the period that the petitioner could not operate due to reasons beyond his control, Your Lordship. Your
What is
Lordships
the
have
reason
been.
beyond his control?
Your Lordship, first is the due to administrative reasons, Your Lordship, as the department was transferred from Revenue Department to the Steels and Mines Department, Your Lordship.
64. Yes.
21 is also similar, Your Lordship.
64.
Same.
Item 22.
Pleasure, Lordship.
Item 22. The petitioner essentially questions if the Lordship would turn to page 44. Lordship will find that here MSTC has issued this email to the petitioner who is a trader, trading license under the OMPTS rules, and has the right of participating in every auction conducted by OMC for sale of iron ore lump and fines. Suddenly, this MSTC, which is the auction,
is restricted to end user industries, not to a trader.
That if your Lordship will, yes, if your Lordship will look at the relevant rules, I am a trader licensee, license of a trader license under definition 2S read with rule 4 and 7 and corresponding schedule. I have a right to purchase iron ore. On the basis of license, I have a right to participate in auction. And if your Lordship, just see page 19. Just see page 19, my Lord. Page 18 is the auction sale notice dated 19/1/26. Here, by the same OMC and MSTC, kindly see page 19, traders shall be allowed to take part in the above national e-auction for all grades of iron ore. This is January auction. Then kindly see page 28, my lord. February auction equally I was allowed to participate. February auction. Our participation is in the interest of revenue to the OMC. Larger participation, larger competition, and it will generate revenue for the OMC. Now
where is the impugned e-auction notice?
The restriction is there. Now the e-auction, the notice they are not published. The auction, the manner they conduct is they do not publish e-auction publicly. Notice. They send mails to us regarding auction of a particular quantity of iron ore, and on the basis of those emails only restricted to traders, we participate. There is no publication of notice, and we bid. We bid at a higher price, even 140, 150. Now end users will reduce it to 90, 95. Like it is a loss to the state organization itself. It's a not only loss of revenue to our prejudice. This they kindly see page 44. They have restricted, they have completely prohibited us from participating in the auction. We were participating.
Where?
Kindly see page,
that is page 44.
Page 44, we are so grateful, my lord. Page 44.
Yes.
Kindly see, this is to inform.
Who is for OMC?
But the OMC, I'll have to take notice. OMC.
Yes, give a notice.
One is basically thus.
Can you give a notice today?
Yes, but today I can give it. Today I can give it, my lord.
Give a notice to the OMC.
Item 23, my lords, may I please your lordship? My lord, this is a matter where the query was initially granted by the Puri temple administration for a period of 10 years. And my lord, subsequently, when the power was shifted in the year 2024 from the Jagannath temple to the mining officer, but in 2025, my lord, the Puri Jagannath temple, after shifting the power, has cancelled my lease, my lord. When the authority is with the mining officer, the impugned order is passed by the sub-collector for the Puri Jagannath temple. That is at Annexure 9, my lords. Annexure 9, page 68 of the brief, my lords.
So a notice has to go, Jagannath temple.
My lords.
Respondent number, the opposite party number?
My lords. My lords, opposite party number 5 and 6, man.
Yes, okay. 1 week after.
Item 24.
24, your lordship, I'm praying for extension on due to the non-operation to the NGT order, your lordship. 1 year, 3 months.
Order 64. Yes.
Item 25.
My lord, item 25, my lord. After depositing all dues, my lord, my case was recommended for registration of the query list, my lord, under Annexure 8. But thereafter, the authorities, it was recommended on 26/11/2025, my lord. But they are not registering, for which I am unable to operate the query, my lord.
Yes, who is appearing for the state?
I'm appearing, my lords.
So why are you not doing it if he has completed all the conditions?
My lords, when he was declared the highest bidder and he was required to submit all the documents, he had not submitted the bank guarantee, my lords, on fulfillment of all terms and conditions. Secondly, my lords, the EC he obtained 4 years after the intimation that he is the highest bidder. Thereafter, my lords, on 29th 11/2020.
If the authority took time to issue a EC, then who is responsible? Has he not applied immediately thereafter?
My lords, he had applied, but my lords, it was only granted on 11th March. My lords, even
So
that.
then who is responsible for a delay? How can you make him responsible for a delay?
No, even if my lords, there is admitted that he's not responsible, but my lords, he had not submitted the bank guarantee, my lords, at the time of submission of
where is the
documents.
contention? Where is the stand that he has not submitted the bank guarantee?
This is as per the instructions which I have received, my lords. And
I have deposited everything, my lord. Thereafter, my case was completed.
my lords, he only.
Please come to page 37, annexure 8. Is a mining officer who is the competent authority. Please read very small letter, then justify the stand of bank guarantee.
Yes, my lords. After the letter of 2611, my lords, another recommendation was sent by the mining officer on 29/11 to the Deputy Director of Mines to allow the extension of time in registration of the lease. My lords, the Deputy Director of Mines, by letter dated 22nd January 2026, rejected the prayer for extension of registration of lease. My lords.
File your affidavit. Disclose those facts.
Yes, my lords.
D'accord. The instant writ petition is filed seeking for a direction upon the
In 26, my lord, the petitioner herein is the lessee of iron ore manganese ore, my lord. Now, my lord, for the iron ore, the penalty was imposed to the tune of 11 crores, my lord, more than 100 crores. Where, my lord, by Honorable Supreme Court judgment, it was assessed, and my lord, it was found that iron ore was it was extracted legally, and for the iron ore, for the penalty, the iron ore, the sale of the extracted iron ore will be sold, my lord. Now, with regard to manganese ore, my lord, that is nothing with regard to manganese ore should be sold to recover any penalty, my lord. So penalty is with regard to the iron ore, my lord. But with regard to the extracted manganese ore, my lord, there is no penalty as such. So, my lord, in that regard, my lord, we have written number of letters to the authorities. And finally, my lord, annexure 7, my lord, may see 114, my lord.
Yes.
Is the on 7/10/2023, my lord. 3 years back, the deputy director, the deputy director of mines wrote, joint director of mines wrote to the deputy director of mines to give us specific views as to there is any to why that manganese ore cannot be transported.
So what happened? It says on the representation, give your views.
Yes, my lord. After that, nothing has progressed. Nothing has come to the fore, my lord. I'm still that manganese ore is there, my lord. Now it has
Yes,
to.
what is this? What are you doing? Why the
My
deputy
lords,
director of mines is
lords,
not taking a decision?
My lords, as per the common cause judgment, my lords,
I
dated.
understand it is a,
Yes,
according to him, it is
it's
the
only with.
demand was, madam, kindly consider, if the demand or the penalty, whatever is ascertained on the basis of an iron ore,
Yes.
can it hover around to a manganese ore?
No,
Because
my
you
lords.
have to make the quantity may be different, many factors may come. So he has already approached the authority. Authority cannot sit tight over it. He's not challenging. But
My
you are
lords,
not.
since only the common cause judgment, since it only allows for dispatch of iron ore, my lords, and not manganese ore, therefore currently only dispatch of iron ore is being allowed. Secondly, my lords, the lease period has expired after completion of 50 years, my lords, as per what instructions that I've received.
But after all, the demand remained on him. Even if it expires, the liability to pay the penalty or whatever that remained on them. So will you not determine the liability part? He says that it cannot be imposed in this way and you can't recover it.
Then, my lords, the representations then may be heard in presence
While
of
you
the
are sitting,
petitioner, my
this
lords.
letter was written way back on 7/10/2023. Now we are in 2026. More than 2.5 years practically have elapsed.
Yes,
What are
my
you
lords,
doing?
but given the fact that the Supreme Court judgment is silent on.
Sir, madam, will you not respond to that representation?
Yes, my lords.
I'm not on that. Supreme
Ought
Court
to have.
judgment may be binding. Will you not communicate to him?
Yes, my lords, that ought to have
Then
been
you
done.
sit tight over the matter. This is what is the irony, and that invites several litigations to pour in the docket of the court.
Yes, my lords.
Sitting idle is not a
No, my lords,
real.
in all fairness, the representation ought to have been considered, my lords, but that opportunity
You
may be.
consider within 2 weeks. You consider within 2 weeks.
Yes, my lords.
Consider it.
My lord, one thing more, my lord, just I want to show.
No more. Let them take a decision. No more.
So by giving us a personal hearing, my lord.
Yes, 2 weeks they have to give.
Annexure 7 joint director, deputy director को लिखते
That decision has to be immediately taken within 2 weeks.
Item 27.
May it please your lordships. My lords, I am challenging the penalty notice under Annexure 5, page 30. Annexure 5, page 30, your lordships may kindly have.
Oh, 51.
In this, my lords, an appeal is also pending before the Deputy Director of Mines, my lords.
There is an appeal pending, my lords.
Yes, then once you have approved, let them decide it.
My lords, your lordships may kindly say within 2 weeks.
It may be
Within
decided.
2 weeks. Within 2 weeks, we are saying.
And it's 4 weeks time, my lords, because the notice has.
It is already pending since for the last 2 months, my lords. They can dispose it of within 2 weeks.
Within
4
3
weeks
weeks.
time.
Average 3 weeks. 2 weeks you say, 4 weeks he said, 3 weeks.
Grateful, my lords.
Appeal. The appellate forum has already been approached.
Against the demand in Annexure 5, appeal has been filed. Sit out Annexure 7. That is stated to be pending. Hello?
Dispose of within.
Item 28.
Grateful.
28, Lordship, in fact, it is a small request, Lordship, to deposit the entire security to money, Lordship, instead of cash, it is bank guarantee. Lordship,
But what is the rule, Mr. Dalla?
It can be hard, Lordship, after vacation of the lengthy hearing is required, Lordship. I want to.
Yes, after
Lordship.
vacation. After vacation. Yes.
That's Lordship.
Item 29.
Please, Your Lordship. My lord, this is regarding the 20% EC and the mining plan.
Yes. What is the law?
Yes, my lord.
Mining plan is subordinate to EC. That your lordship last occasion section 87 of the common cause judgment your lordship have gone through. Well, what I pray, this matter requires a hearing. And here we are also required to file a counter affidavit. Your Lordship may keep it immediately after vacation so that we can file the counter affidavit. And if your Lordship can here, because that issue has to be decided, because this matter has implication over other matters also. May I pray, let it be taken up after vacation so that we can file the counter affidavit.
My lords, I have no objection to what my learned friend says, subject to one small my lord request from my side, that pendency of this writ petition should not be a reason for stopping my MDCC for years together. Because
No, it is not for years together. My lord, the demand notice has been issued, and the difference of EC, basing on the difference in the EC limits, permissible limits in the EC and the amount of mineral extracted. But on that, the demand notice has been issued. So let him also deposit.
The difficulty is because IBM has to consider it. They have considered, they have permitted 10% initially, then enhanced to 20% thereafter. Now, what would be the impact thereof? That has to be considered. Mining plan may be subordinate to EC, but again, the decision which is taken by a highest body, that is a statutory body also.
The revisional authority has taken a decision that is under.
Yes, so that is to be taken into account, that what would be impact thereof.
Yes, Manu.
This 10% difference, whether that can also be inbuilt into it. That's the only thing.
Inbuilt into the EC also.
That is the only thing.
That is the only issue, my lord.
That is what is there. So what is the role? What counter you will file? You can agitate it. Or you want to file, keep it on, which is the day after the reopening?
That will be, I think, 22nd.
No, 22nd, these matters are listed when?
23rd.
23rd. So
23rd.
file it by 22nd. Counter by 22nd. Matter to be listed on 23rd at a specially fixed matter.
And if your lordships can grant us that indulgence to approach for the MDCC, if they can consider it, because otherwise...
What is that?
My lord, that mineral, whatever has been extracted, MDCC, my lord, that clearance certificate. So issuance, otherwise, without that MDCC clearance certificate, we cannot transact with the, before the port or anywhere, no transportation, nothing, everything has been stalled. We are ready to will deposit, my lord, subject to your losses 20% of the demanded amount to show our bona fide also.
Well, let them deposit 50% then.
But issue has to be decided. We have to show, we have to do business. We can't
immediately, your lordship may take it up immediately after vacation.
Run our business also.
No, Mr. Nando is also correct that after all, it's the running of the business. So what more? Mr. Das, you also take instruction. Mr. Nando, you also take instruction. The modalities of payment as an interim measure.
Before the honorable court will
we are keeping it physically. We will be available, and you come.
As your lord. As your lord.
Tomorrow we are keeping this matter.
If it is only for this purpose, can be kept on the top of the list so that within 5 minutes it can be.
We'll do that.
Yes, then the matter can be heard after vacation.
Yes.
DPO.
Item note 30.
Office note order number.
Item number
30.
30 or 31.
Item 30, Lordship, Lordship, state I have come to page 17, Lordship. Lordship, I am busy.
17.
17 Lordship, para 13. This issue is already been decided, Lordship, by this Honorable Court. Para 13 and 14 two paragraphs is very
So
important.
after 2022, Tehsildar does not have a power.
That full Lordship. Lordship, just on page 18.
Where is the order impugned?
Lordship, I have quoted Lordship, the entire quarter, it starts from page Lordship. Just I'm drawing a Lordship.
Show me that who has passed an order straight away.
611 টা ଦେଖନ୍ତୁ
That is the mining officer.
Page 95, my lords.
Yes,
Annexure
Lordship.
9.
The direction was very specific, Lordship, to pass order by granting reasonable opportunity of hearing to me. Lordship, they have not intimated anything, Lordship. This officer status has passed this order by forming a committee and has recommended only we came to know by private petition.
Mr. Dalai,
Lordship.
The order which is impugned.
Annexure 9, Lordship.
Officer.
Annexure 9, Lordship, that is page 95.
95, that is passed by mining officer.
Lordship, no, he is sending the committee, Lordship, reading the language, Lordship, with reference to the subject cited above, as per order dated 16/10/25 by Honorable High Court of Orissa, WBC number such and such, a committee has been formed to take fresh decision on the auction process of Dighi 2 sandbed, and a committee declared Gideon Simmons as the highest bidder, and the proceeding and the copy comparative statement are attached herewith for a kind infant necessity action. And this was never intimate to me. Only this piece of document I got only by filing a caveat petition by the opposite party. Lordship, I till date enter the direct also in that, Lordship, kindly say Annexure 10, Lordship, Annexure 11, Lordship. The director sending a letter to the mining officer, please supply those documents. The ministry director also in that, Lordship. And Lordship, kindly see one document that I am the highest bidder. That is, Lordship, kindly see page 49, Lordship, page 49 of the brief. 49, serial number 3, Lordship, page 49.
No, that report has been furnished to a joint director.
Lordship, we don't know, Lordship, that has never been supplied to me.
Ms. Das, on the basis of the representation, the joint director has taken note of it and has approached the deputy director of mines to you, please furnish all those details. Has he furnished?
My lords, that instruction, though I don't have, my lords, but I have the proceedings with me, my lords.
No, kindly come to page 100.
Yes, my lords, I've seen that joint directive.
Has he furnished? He wanted a clarification, all these things.
Yes, my lords, but my
Whether
lords,
opportunity of hearing is given or not, verification of the eligibility, everything has been done.
in all fairness, my lords, opportunity of hearing has not been given in this matter, my lords. The documents were perused by the committee, my lords. And after perusal of the document, the petitioner was not found suitable because he had given one solvency certificate for various tenders, my lords, and hence his bid was rejected. And the successful bidder was called upon.
Are there any conditions that he cannot give the same solvency certificate?
My lords, section 27, rule 27(4), subclause 4, my lords, of OMMC rules, my lords.
Yes, just 1 minute. 27.
Subclause 4, Roman 4, my lords. My lords, I'll read 4 and then subclause 4.
Rule 27.
Yes, my lords. A grant of subclause 4. It reads that subject to other provisions of these rules for settlement of the query list.
No, I'm getting a older book, I believe. No, but 2026 book. Are you reading a older book?
My lords, I'm reading a 2024 book.
That is the whole problem because in 2026,
27 has been
substituted completely by
2025.
2025, madam.
My lords,
on 28th of November 2025, it is substituted.
My lords, if I may be given, I'll just see it on the website once. But they have also in the report, my lords, proceedings, they have referred to 27(4), subclause 4, my lords.
But in the new one, there is no subclause 4. I think they also relied upon the older provision, which is
Joint Director, 2nd
the
February.
Director of Minor Minerals shall have to concur in at least 10% of the cases approved by the controlling authorities within 10 days, 27/4. It is something which is absolutely a minimum guaranteed quantity. Mr. Deloy, don't keep quiet or
Lordship,
what is your...
Lordship, my answer, Lordship, kindly state that come to page 49 for a moment, Lordship. Page 49 of the brief.
No, 49 of?
49 of my brief, Lordship, 49.
Yes.
Lordship, 49, Lordship, kindly see. This is a proceeding dated 27/8/2024. Page 49, Lordship.
Yes.
Lordship, by virtue of this evaluation, Lordship, my name is serial number 3, Lordship, kindly see Dilip Kumar Sahu. Lordship, kindly see the last remarks column. I declared L1, Lordship, highest bidder.
No, about this provision of law.
Yes, I will answer, Lordship. I will answer, Lordship.
Yes.
Lordship, kindly come to Lordship. I declared the highest bidder. Then Lordship, kindly come to page 70, Lordship, for moment, Lordship. What the committed
70 or 17?
17, Lordship, 17. Your Lordship's order last two paragraphs, Lordship. 17.
Yes.
Lordship, para 13.2 small paragraphs on reading, Lordship. We thus find that the Tahsildar sub-collector is neither competent nor assumes the powers after the amendment.
Oh, I understand it, but it appears that there has been a correspondence by the mining officer.
No, Lordship, I'm coming to that, Lordship. Lordship, let me complete only two small paragraphs,
Yes.
Lordship. And therefore, the decision of steps taken by them in issuing the said input notices or taking any decision subsequent thereto are without jurisdiction and cannot be sustained in the eye of law. Then 14, Lordship, the Tahsildar sub-collector is directed to transfer all the records to the mining department and the competent authority under the amended rules 2022 shall take fresh decision after adhering the principle of natural justice within 4 weeks from the date of the communication or judgment. So, Lordship, had it been their case that my solvency are defective, they should have been called upon me to explain, Lordship. Once you declared me L1, I am ready to, Lordship, perform the contract. At the same time, you come up with a resolution by the incompetent authority. Your Lordship, was that order?
I understand, sir. They take a fresh decision. I understand. Then they have taken shelter under a particular provision of the rules.
No, that is complete wrong, Lordship. Had it been, Lordship.
She is saying that solvency certificate can only be used once.
Yes, I have used once, Lordship.
Multiple.
I have used
I am
once.
asking where is the provision relating to this?
They have
a prohibition. I am unable to get it.
Lordship, I don't know what steps, what proceedings they have taken, Lordship. That is unknown to me. But
now she is taking, it is unknown to you. What are you talking?
No, Lordship, they have never supplied to me. Lordship, that is the entire case.
Now Ms. Das is taking the stand that you have submitted one solvency certificate covering multiple ones.
No.
He says that it is not permissible.
No, it is permissible, Lordship. If it is within
Where is the provision which talks about the solvency certificate and the restrictions created? I just wanted to look at the provisions, sir.
Lordship, they are referring to old rules, Lordship, 27.4. They are referring to old rules, Lordship. But Lordship, just may I read, Lordship, 27.4, what is the language of Lordship? A solvent certificate or a bank guarantee, validity of 18 months of an amount of less than the amount.
Mr. Dalai,
Lordship,
you are also referring to old book.
No, they are referring, I don't know, Lordship, what they are referring. Only available, it is old rule, Lordship. New rules, that is not available.
No, under new rule,
Lordship.
where is the provision for submission of this solvency certificate?
That solvent certificate, that Lordship, can come new rules, Lordship.
Old.
So what they are reading? Let us see. Yes, what are you reading?
My lords, the new rule, my lords, my lords, the new rule, it is 27.7, my lords.
27.7?
7, yes, my lords.
Okay.
27.7.4, my lords.
Yes.
income tax return of previous financial year showing annual income for amount not less than the amount of additional charge for the minor mineral offered and the royalty payable for the minimum guarantee quantity for 1 whole year or bank guarantee valid for a period of 18 months for an amount
that
not
is
less.
different. But here, you are talking about solvency certificate.
Solvency certificate.
You are reading. This is not a solvency certificate.
This is what they are referring to the solvency certificate, my lords.
No.
Because-
There is a language which is used. He was reading the solvency. What is the provision, Mr. Doloy? Old one?
Lordship, in old lordship 27(4) Roman 4 lordship.
Yes. What?
A solvency certificate lordship. A solvency certificate or bank guarantee valid for a period of 18 months of an amount not less than the amount additional charge offered and the royalty payable for minimum guaranteed quantity of 1 whole year and a list of immovable properties from the revenue authority. This is the requirement under law. So, lordship, if that everybody has one solvency certificate, lordship, it comes within that purview, he can use that solvency certificate in different participation, lordship. So that solvency certificate within that limit, lordship. So my solvency certificate never lets me cross that limit. That is within my limit. That's why they have selected me L1. Now this committee, lordship, after lordship's direction, they have reversed that.
Then I do not find any prohibition that he cannot. How the authority arrived at it? From where they got it?
Lordship, that they should, lordship.
From where they got it?
At least they should tell me to explain.
Where they got it?
My lords, if I may just read the instructions which I have in front of me, my lords.
Madam, the instruction must be in consonance with the law.
Yes, my
when
lord.
they give you an instruction, when you have an occasion to read the provision of law, will you be able to satisfy your own conscience?
Yes, my lords.
That what they are saying is in accordance with law.
Yes, my lords. My lords, here what had happened, my lords, here the solvency required was approximately 2.54. My lords, if I may refer to Form M, which is annexed to the old book, my lords, it refers to solvency certificate, my lords.
Correct.
So here, if the amount required was approximately 2.54 and he had given for 2.54, it is it was found out by verification of document that the same solvency certificate he had used in other sand bed.
Madam, please, I am believing that I am breaking my head before a solid rock wall who is unable to respond. I am simply asking you if there is a solvency certificate which he has issued showing that I am solvent to the extent of this. Where is the prohibition or a contention or a provision that once you have used it for some other purposes, it will be reduced gradually by virtue of a quantum and therefore you cannot use it? Where is the prohibition? Where is the provision? Tell us, can you take innovatively done?
No, Malaj, there is no direct provision. Only thing
So
which
how can you declare him invalid?
Only reason, Malaj, if I may read that.
You can't act beyond the purview of law.
No, Malaj.
So that's all.
Only 27.4, Malaj, if I may read once again.
Justify the action of an authority who does not know or do not have a care to respect the law.
No, Malaj, if I just may read 27.4 for my satisfaction.
Read that.
Income tax returns or solvency certificate, which my sir.
No, madam, you can't, because this was done at a point of time when this amendment did not come. Amendment came on 28th of November 2025.
Yes,
so you have to follow the unamended rule which was there at the time.
Yes, my lord.
Now this unamended rule, Mr. Doloi read, it talks about a solvency certificate and does not contain any provision relating to multiple use of that solvency certificate. I am asking you very simple question.
No, my lords, there is no specific bar, my lords. I agree to that.
If there is no bar, can it act against him to his detriment? I am asking.
My lords, only reason this clause is referred is, my lords, what that solvency certificate will show, my lords, what is required. It will show that annual income for the amount not less than the amount of additional charge offered and the royalty payable for the minimum guarantee quantity for 1 whole year, my lords. If he does not meet that requirement, my lords, then he will not.
You say if he says that, look, this is my certificate, this meets the requirement for a whole year. It may be that I have used this certificate for other, where also I have shown my solvency. Please consider, I think I am unable to match the frequency of mind with you. The provision does not say that there will be a the reduction or there will be a deduction of a particular amount. Now the question is, again I'm saying, if somebody has a solvency to the extent of 3 crores, he has used this solvency certificate for obtaining, securing that royalty for another purpose or another sand mines, whatever, to the extent of 2 crores. Again, he says that, look, I have a solvency for another period of, say for 2 crores also, because it is a 3 crore. If the authority say that I will deduct that particular the amount from your solvency certificate, there must be some rule, there must be some provision, there must be some kind of a the GO or a government circular, government order. There must be something. Can an authority overnight, he will say, I will do it?
No, my lords, it
Without
cannot be done.
any authority of law.
My lords, only, my lords, if I may refer to
I
page.
appreciate what you are saying, but there it must be backed by some document.
Correct,
There's
my lord.
nothing. There's nothing. Rule does not prescribe.
So, my lords, if he does not, the only respectful submission is that if he does not, if has that much solvency for the conducting the sand query, then he will not be able
Talking
to.
about, madam, you are talking about whatever the solvency certificate which has been placed before you. There is no provision that he has to disclose.
No, there is no
There's
provision.
nothing.
There's no provision.
Then from your sources, if you have got something, can you act to his detriment?
My lords, in the same bed, my lords, in the same area, it's Digha 1 and Digha 2, my lords. In Digha 1, he had used the same thing, and Digha 2 also he had said, my lords, page number 44. Initially, Tehsildar had also
Madam,
issued.
probably, I think it's my incompetence
No, my lords,
to percolate what I have said.
my lords, I understand.
The basic fundamental principle of the administrative jurisprudence is an individual can do anything unless prohibited by law. But an authority cannot do anything unless provided by law. You can act within the presence of law. Tell me where is the exercise to be done. Provision must be very clear. I am asking you, the provision does not say anything. It says the solvency certificate containing this in a prescribed form is to be submitted, which he has submitted.
That is correct, my lord.
No prohibition. There is no restriction. You have of your own will devise. There is no government circular. There is nothing. I am asking this question. I am now unable to percolate my mind to you.
Well, I understand, but this is.
You are still singing in the same tune because your authority has given you instruction.
Well, it's page number 44, my lords. Initially, show cause was also issued citing the same reason, my lords. Page number 44 by.
Can you issue if there is a mandate that you cannot hide it or you have to disclose it? If they have not disclosed it, I can very well appreciate that you can issue a notice. When there is none, then whimsically you will issue a show cause notice. Is it not really furthering or giving impetus to some kind of a favoritism or a nepotism? You want to eliminate the highest bidder by hook or crook, taking whatever the steps not permitted in law, divorce the law. You just anyhow want to get rid of the highest bidder. What is the purpose of then the floating a tender, inviting the bids? The lowest price, highest price, the concept is the fairness, transparency, everything. You are eroding it by virtue thereof. Taking a plea which is not permitted in law, nor prohibited in law, nothing. No matter, this can't be done.
It's here the after this.
Show us the law that you can take any decision, divorce the conditions of the tender, divorce the provision of law, as you think fit, you will do it.
No, my lords, that is not my
And
submission.
will be very happy. The whole country will run in
my
this
lords.
way.
No, my lords. The only thing is that
What are you talking? This is not a law. You should respect the law. You should act within the four corners of the conditions which you have put. You can't travel beyond it.
yes, my lords. Let's hear opposite party number 6 has actually matched and given higher quantity now, my lords, after this.
Madam, the difficulty is there are 2 or 3 ways of doing it.
Yes, my lords.
One is that if you have invited the bid, then whoever has quoted the highest price, you'll have to give it. If you have also taken a provision that the negotiation has to be taken place because you do not want the entire the contract to be given to one, then you can invite a negotiation to a highest second bidder. But whether you want to match the highest bidder, I can appreciate this. But there must be something in the tender document itself. There must be something in the statutory provisions. You can't do it in this way. And when you can ask for S2, when the H1 has
Denies.
either declined or refused to do it, then you can call the S2.
Yes.
This is not a way. Yes, we are coming back and then dictating it. Now it is 1:30.
That's grateful. Yes.
Yes.
I think item 30, your lordship had fixed it to for passing order after lunch, my lord.
Yes, I will do it. Dictate it. Don't worry.
My lord, I'll just take. I am appearing for OP number 6, my lord. I'll just take 3 minutes, my lord. I'll not take much of your lordship's time, my lord.
Where you were, sir? Where you were?
I'm so sorry, my lord. In fact, there was a motion for my lord passover being made, but I'm so sorry, my lord. That is, I couldn't attend. Only I'll not take much time. Only 3 minutes, my lord.
What for? Everything has been heard.
No. Well, I'll just assist, my
Only
lord.
thing is we wanted a single question.
Yes.
Solvency certificate. The rules are there. Whether you can innovatively devise something which is not provided in the law.
No, I'll answer exactly that point, my lord.
Yes. What is your answer? Tell us so that we will dictate. Just wait for 31. Just wait for 31.
Yes.
Yes. Show us the law.
My lord, in fact, the tender notice was of the year 2021, my lord. The tender notice was of the year 2021.
Yes, there was an old act. There was an old act. Rule 2744 was invoked.
Yes.
2744 does not create any kind of a mechanism that once you have used, it will be deducted and it will not be used for any other purposes. Where is the provision? 2744.
I'll just read that, my lord. That is in fact by taking.
Please, it was read twice. You can read for the 4th time again. 4th time. Read it, what it says.
I'm sorry, my lord. Since your lordship has gone through the provision, my lord, I'll not repeat, my lord. But I'll simply, my lord, urge upon your lordship that the committee in fact rejected his application only on the basis of 2744, my lord.
Yes.
By saying that whatever solvency certificate he has given, my lord, that was for a particular Syrat, and that solvency certificate could not be used for subsequent Syrats.
Where is the prohibition? Show us.
Well, only
there is no prohibition. There is no prohibition. There is no mechanism.
Well, otherwise than 2744, there is no other provision, my lord.
Then
so that is how they have interpreted to get it done.
Can you take a recourse which is not provided in the rule, or GO, any kind of a government order, government circular? I can understand anything. You show us, nothing is coming out. How the authority can pick and choose?
My lord, can I read it again, my lord?
Please read it. Read it for yourself.
That said, subject to other provisions of these rules, for settlement of the query lease, the intending applicant may apply to the competent authority and a sealed cover for the grant of query lease for such area or areas in Form M in triplicate accompanied by the following documents. Then 4, yes. Roman 4.
Yes, please.
A solvency certificate or bank guarantee valid for a period of 18 months.
Correct.
For an amount not less than the amount of additional charge offered and the royalty payable for the minimum guaranteed quantity for 1 whole year. So, it says a solvency certificate.
Yes, I have seen this proposition. I know, I have taken a decision. I have delivered a judgment in Calcutta High Court. What is the impact of it?
So I'm grateful, Malad. So that is that I just take a leaf from your lordship's book, Malad. Just to say, Malad.
Please consult GP Singh's statute, the interpretation of statute where one particular topic has been dedicated there for A, N, and the.
And that is the reason I am emphasizing upon the word and the decision taken by the authorities, because that amount of 2 crores 59 lakhs is inadequate, Malad. For the purpose of
No, it is adequate as per the format, but they say that since he has also applied the same solvency certificate in another, so on that basis, it is less from where he got it. I just wanted to know.
Accepting this, in fact, the clarification ought to fall from the government. But I can only say
that is what I say. There should be a clarificatory note. There should be a clarificatory government circular order. I ask. There is none.
Can I just not say one sentence and conclude, Malad? That one sentence is Malad. Then Malad, the entire process will become will become odious for the simple reason, but the solvency certificate of one particular amount, one can operate in 5-6 queries.
Sir, there is no certainty that he can be adjudged as the highest bidder in all. Can you consider the flip side of it?
It is contingent.
Please consider, if he has applied for 5, he may not be highest bidder in 4, but he has applied for others. So 5th also becoming a highest bidder, he has to be thrown out. Is it a correct way of understanding, sir?
That is the only thing is
you'll have to see both the pros and cons.
Equal distribution and giving opportunity for all. Where is the sole purpose.
Where is the ratiable calculation? There is nothing. I just imagine that only it talks about there cannot be multiple solvency certificate. It has to be one. Solvency of a person is an individual one. Can he say that my solvency in this tender is more, my solvency in another tender is less? He has a similar uniform solvency. Now the question is that if he has applied for 4 and it appears that in 3, he is not an highest bidder, he is not awarded, but he is a highest bidder in the 4th one, then what would happen, sir? Since he has applied for others, so he will not get it and he will be disqualified here. Sir, that is, I think, unreasonable, unthinkable, sir.
I simply, sir, just to do away with.
No, sir. On the day of his application, sorry, I don't think so. On the day of his application, he has to.
That is all I want to impress upon lordship.
That is what we put a question to Aishwarya Das.
My lords, I have placed the proceedings, my lords, with the records, my lords, for your lordship perusal.
We understood that you have taken a decision. Let us understand that what is the law. We do not have the unamended copy. We just wanted an amended provision so that we can quote and then interpret it. The old one, unamended. We have the amended one. Because this has been amended, the entire rules 27 in 28th November 2025.
Yes,
all these aspects being argued because this entire tender process emanated in the year 2021. That is why we are
So the law which was prevalent at that point of time has to be understood.
yes, exactly, my lord. Exactly, my lord.
So that is what we wanted. We don't have a book. We are on a virtual mode. Yes. Yes. 31.
Bless, my lord.
Grateful, Lordship.
31, my lord. Here, my lord, last occasion court directed that to take state to take instruction with regard to my transportation of molasses, my lord. Here, my lord.
In this matter, I have received instruction that earlier he has filed an application for granting permission for transportation of molasses. That recommendation has already been rejected recently on 22/4/2006 to 2026. That rejection order has not been challenged. Thereafter, again, another representation and filing of the present writ application. And the original writ application is still pending. While your lordship has directed for deposit of the entire amount which demanded has been made against him. He has deposited the amount before the registry of this honorable court, and matter is now sub judice. It is to be decided. Again, after rejection, another representation, and including the representation, the present writ application has been filed. And the writ application, the prayer is made to grant him permission for transportation. He wants to procure molasses. He wants to procure molasses without having any license. License is a mandatory in view of Rule 34 of the Odisha Excise Rules.
Yes.
Yes.
My lord. With regard to rejection, my lord, I don't have any instruction.
Two.
Wait, please, your lordship. Lordship, the matter relates to establishment of one PHC, that is primary health
Sir,
center.
what order you sought to review?
Is at Annexure 1 of the review petition. It's page 7, your lordship. The relevant page is page 9.
Yes.
Let's see page 4, paragraph 5 of the review petition, Miller. My humble submission is that it's not a ground review.
Oh, just 1 minute. Let me first understand from the petitioner. Yes, we have gone through the order. On what ground the review you have sought for?
Lordship, the PIL was dismissed in a mechanical manner.
So that is the review. That is the review. Whether you were an arguing counsel?
No, Lordship.
So why not the judgment of the Supreme Court in AIR 1997, Supreme Court 1005 or a 6 be applicable?
5. 1005. 5.
Why it is not applicable, sir?
Lordship, may kindly post it to after vacation. I will go through the judgment.
Yeah, please go through the judgment.
Obliged.
You have not taken note of it. Please take note of that judgment.
Obliged.
You have not written it. What judgment you will go through?
1997 AIR Supreme Court 1006.
5 or 6, whatever.
1005.
Is on the prayer of the petitioner after vacation.
33.
I may please your lordship. My lord, the order passed in the writ petition number 139 of 2026 at page 18 is read for review, my lord.
Yes.
In this order, there has been mentioned that the remedy challenging the order passed by the authority in exercise
But
of
why
power
the review,
given
sir? Why the review, sir?
there is no provision of appeal or there is no provision of revision to challenging this order.
But can it be done in the PIL?
Yes, my lord.
Or it can be done in a writ of certiorari? I am just asking, does it partake a character of PIL or it is a writ of certiorari?
It is a PL
That
because
is what the court,
virtual land
that
has
is what
been
the court has held. That is what a court has held.
Yes, ma'am. So there is no appeal provision or revision. For that reason,
Are
REIT
you
is
not
only.
understanding? Are you not understanding what we want to say?
I
am simply asking whether the PIL is the proper remedy or it is a writ of certiorari is a proper remedy. I am simply or a madam as what?
Order passed under statute can be filed in PIL also.
PIL, show us the judgment, sir. Show us one judgment. I'm simply asking one. Show us.
I will place my let it come after vacation for this. Because
Second question is, sir. Second question is, can a court go into such aspect in a review jurisdiction? Tell me, you have filed a review application. Tell us what is the scope of a review.
My lords have delivered a judgment, my lord, in the case
No,
of.
you need not have to, Mr. Tripathi. You need not have to. I'm asking this question to the counsel for the petitioner who has filed a review. Yes.
As it is a misconception, fact review is maintainable.
What?
As a misconception of law, it is a review is maintainable.
Is a misconception where? What is a misconception of law where you have stated
there is no
that what
there
is
is
the
no
law?
appeal provision.
No, we have not said so anything that there is an appeal provision.
Yes, conferred under the statute and therefore it does not participate.
Suppose that we have not said the appeal provision. We have not said any appeal provision.
The petitioner
Where we
intend
have
to
said-
pursue the remedy challenging the an order.
That is why I say
In
there is
para
no
2 minutes.
provision for an appeal before any appellate authority. There is a remedy. Remedy does not appear to be a public interest litigation. That is what we heard. Sure. That any order passed by an administrative authority in his administrative capacity under this statute, PIL will be filed. Simply on challenging that order without any further impact on the larger public. Individual interests. Sorry. The instant review application is
34, my lord. May it please your lordships. My lords, here there was a company, East Coast Fertilizers, my lords. Now this company became sick under the erstwhile Sika Act, my lords, and where the government, this honorable court had to hear on the question of liquidation. And accordingly, this court heard the matter, and on 12/8/2005, my lords, this honorable court directed that the company should be liquidated. Thereafter, my lords, there was a direction to the official liquidator of the Honorable High Court, which is at Annexure 2, for selling of the assets of East Coast Fertilizers and Chemicals Limited in liquidation.
But there are two judgments of the Calcutta High Court which I know that you have to pay the stamp duty, you have to pay the registration fees, you have to, if there is any transfer fees which is imposed, you will have to pay.
Exactly, my lords. That has also been specified in the sale notice, my lords. Annexure 2 at running page 18.
So you are challenging a transfer fees.
I'm not, this transfer fee, my lords, if your lordship kindly sees.
This is what you are challenging it.
Yes, my lords. The transfer, no, your lordships will kindly see what I have to pay. If your lordship sees annexure, my lords, page 20, page 21, at paragraph 11, legal charges for conveyance, stamp duty and registration charges as applicable is to be borne by the purchaser only, my lords. That we are ready to bear off.
That is what I'm saying. You are challenging the imposition of transfer fees. But
your lordships may just see the impugned order.
Page?
That is at annexure 10 at running page 59. Lordship gets it.
Yes.
My lords, the other portions I'm not challenging, my lords. Only I'm challenging this transfer fee, my lords, which is not contemplated of anywhere, my lords.
Who is appearing for IDCO?
IDCO, my lords, notice has to go.
Notice 1 week after.
Deeply obliged. My lords, after the vacation?
Yes, 1 week after. We have said 1 week after the vacation.
Yes, obliged.
OFFC, who is appearing?
OSFC, my lords, again notice has to go.
Yes.
EPCOL also.
EPCOL also.
Yes, ma'am. To everyone, my lords, notice has to go.
Except the government authority.
Except the government, my lords.
Item 35.
In this case, the petitioner has challenged the illegality and impropriety of the order dated 3/2/2025, Annexure 12. In this case, the petitioner has challenged the
page.
Annexure 12.
Page
50.
50.
This is also IDCO.
IDCO. Notice has to go to IDCO, man.
Page 12, 50, 51. Already, this case is covered by.
Cancel the allotment. Issue a notice. You go there. You did not submit the reply to Ashoka's. So they have proceeded ex parte.
No, I have submitted my reply.
So just let them. Notice has to go to them.
Yes, notice has to go to them.
Yes, 1 week after the reopening.
Well, status quo as on today we
But
maintain.
no, sir. Cancellation has come. Yes.
Notice. 22 তারিখ.
Call.
36.
36, I am appearing, my lord. If your lordship looks at page 81, Annexure 21, It's later dated 23/20/26.
All IDCO.
IDCO, my lord. Actually, IDCO, your lordship asked me to serve a copy. I had already served a copy on the returning council, but they say actually we can't accept because you have to, a panel of lawyers are there. We cannot appear individually on the basis of the service of copy.
So now then what to do?
I have to take notice on IDCO.
IDCO and EPCOL.
EPCOL, both.
Again, notice. Like what is submitted by Mr. Mishro, the senior.
And they demanded a part of it. I have deposited 72 lakhs on the basis of their demand. After that was deposited, they revised the amount. So that is a subject matter of dispute. But when I say that you cannot revise it when you have accepted a part of it on the basis of which it has been accepted, they called me that you approach the appropriate authority for exemption. So I approach the appropriate authority. While passing an order, this Annexure 21 has been passed, therefore we cannot accept. But the proposal to allot is cancelled without any notice, without anything, which they cannot do, Melody. They should have given a notice.
Where is that?
Page Annexure 21, page 81. They have received 72 lakhs, Melody. I have deposited, I have also given the document. Page 21. The first paragraph, you request for revision of the land cost from 75 lakhs per acre to 25 lakhs. It was originally 25 lakhs per acre for deposit the cost, and that has not been considered by the management IDCO as the revised land premium of land so and so cannot be reduced. Then he passes an order that is cancelled.
Then after that, what you did?
Sir, I am before your lordship, my lord. And interestingly, a person who applied after me, same rate, Annexure 22 NLC, same rate. The revision rate was not made applicable to him, and he was asked to deposit on 25 lakhs per acre. Annexure 22. This single window recommended both the units. And interestingly, I deposited the part money as per their letter. Annexure 5, page 55, if you also look at it. Right.
The challenge is made to the letter dated 20th March 2026 issued by the ITCO.
Wait, please, my lords. 37, I'm appearing, my lords. This is for, my lords, the lordship remembers on the last occasion. I filed a
It is ready, my lords. I don't know since Mr. Palith is not in town, I don't know how it can be served on his office. Counter affidavit is otherwise ready.
I don't receive copies, as you also don't receive copies. So you can always
Nobody
serve it on
available
the
in the
AOR.
office, and hence it could not be served.
No, not my office.
It is
not my
always
office.
served on the advocate on record. How can
On
a
the
senior
advocate on record.
designated advocate receive it?
My friend should know
We'll
that.
serve it in course of the day.
My lords. My only difficulty is, my lords, that I need some kind of an interim measure protection, some interim measure, my lords. In the event that the work order is issued, my lords, my writ petition becomes infructuous. And I am lower than the L1 bid by 28 crores.
I understand.
I've given an additional...
We are keeping this matter day after tomorrow. And in the meantime, the advocate and record should be served with a copy.
I'll serve.
My lords, day after tomorrow may be a little difficult. Can your lordship have it tomorrow, my lords?
Friday.
Lordship may have it tomorrow, my lords?
Friday.
Friday, my lord. Lordship's the last working day, so maybe.
No, I can have the copy picked up from Mr. Mukherjee's office.
Yes,
Lordship will call it tomorrow?
Tomorrow.
Grateful, my lords.
Tomorrow.
38.
Wait, please, my lords. On the last occasion, your lordship passed an order on 30th of April. There's an income tax matter, 148, my lords.
Yes.
What happens in this case, my lords, is your lordships had once already examined the 148.
Why this matter is now listed before us? There is already an interim order which is going on.
Yes, my lords.
So
that's all, my lords. They have to file a reply.
Why you have listed it? At whose instance this matter is listed as a new matter?
Not, my lords. I believe there is a direction in that order. List the matter on 19th May, para 3, 30th April 2026.
Your lordship in last occasion.
That's why the registry has listed it in compliance of your lordship's order.
Yeah, your lordship in the last occasion only the
Mr.
Yes.
Extend.
Yes.
Have you filed your response, Mr. Kedia?
Your lordship, on last occasion, copy was not served. Only the court has directed to serve the copy, and till then the matter was stayed. Here matter need a hearing. Then we have to file a counter. In this case, on the basis of Rajiv Bansal case,
Mr. Kedia.
Your lordship.
Have you received a copy of this?
Yeah, your lordship.
Would you file counter?
Your lordship, in this case, alternate remedies.
Shall you file counter?
I'll be filing counter.
That's all.
File counter 1 week after, rejoinder 1 week there.
Well, I believe the report has come before your lordship. As per your lordship's order, 13th of May, 13th of May, para 5 onwards, your lordships felt that a special officer was required to be engaged, and he was engaged. He has visited the site and submitted a report. The urgency involved.
Physically, we want to hear. The special officer.
Condemnation second item.
In the second item, the condonation has been done. Yes, it has been done. I believe.
It has been done.
Yes, it has been done. I still.
Yes. Second matter, I am appealing.
Where is the special officer?
My lords, I am in court.
Oh. Can we fix this matter for a physical hearing tomorrow?
My lords,
Because the hearing of the special officer, his report has to be.
Report I have submitted.
Yes.
To the court master.
So tomorrow, can we fix this matter?
My lords.
So,
can I pray tomorrow as the first item on board?
Second item, the condemnation.
I think.
Second item, sub item. First item.
There was a small, very short period of delay. I think your lordship had condoned.
Yes, I believe that we have condoned or not condoned.
No,
already condoned.
My lord had been pleased to condone, but if it's the least showing.
Mr. Misra.
My lord.
In WA number 268/2026, who is appearing?
I am appearing.
Mr. Tusa, yes. Has it been
in your appeal, condonation has been done?
On the last date,
Your Lordship had,
we are just checking.
Your Lordship had passed the order in court, condoning the delay.
Oh, it is not uploaded anyhow. Yes, it has been condoned. Yes, tomorrow, either as a first or second matter, whatever.
Obliged.
Precisely fixed matter.
Itu cutting is
Yes.
submit upload in
Okay.